The National Company Law Appellate Tribunal has held that a dispute arising from an employment contract concerning the determination of emoluments and salaries to be paid to an employee of a company after his termination cannot be adjudicated by NCLT or NCLAT under Insolvency and Bankruptcy Code 2016. This has been held in the case of Akhilesh Kulshresht versus Messer SAAB India Technologies Private Limited, and the case number is Company Appeal 80 Insolvency number 353 of 2020. The NCLT New Delhi Adjudicating Authorities ruling dated 29 January 2020 in CPIB 1972 of 2019 was contested by Akhilesh Kulshresht, the appellant under Section 61 of the Code. After the Section 9 application was admitted, the appeal was granted on August 25, 2022, and the case was remanded to the adjudicating authority for further orders. Liberty granted to file fresh application does not permit alteration of default date in application under Section 7 of IBC, the NCLAT has held. In order to challenge the order, Messrs. SAAB India Technologies Private Limited, the respondent filed civil appeal number 5923 of 2022 before Honorable Supreme Court. Honorable Supreme Court then remanded the case back to the Appellate Tribunal on 14th August 2024 to decide whether the appellant was entitled to the same salary and benefits after resigning his position as Chief Financial Officer in his capacity as a director alone. The parties were instructed by Honorable Supreme Court to re-argue the case with pertinent supporting documentation. According to the appellant, the respondent failed to pay the salary and other dues of Rs 30 lakhs and odd for the period of March 2, 2019 to March 20, 2019, during which he purports to have remained a director even after his employment as CFO was terminated. It was further argued that the records the respondent provided to several statutory agencies showed that he was receiving compensation in both his roles as CFO and whole-time director. In contrast, the respondents argued that the appellant was only entitled to Rs 9,50,000 per month as the respondent's CFO under the terms of employment contract, and that the appellant was not entitled to any further compensation as the whole-time director role. The tribunal found that form number MR1 is a statutory filing required under the Companies Act upon the appointment of a director. The form does not indicate that the appellant was receiving separate compensation as his role as whole-time director. The New Delhi bench of NCLAT held that the designation of whole-time director was selected in form MR1 among other roles including CFO solely because the form permits only one designation to be chosen. The stated annual salary was Rs 86 lakh and odd, represents that his total remuneration, not additional payment for the directorship. It was viewed that as per Article of Association, the payment of remuneration to the appellant as a whole-time director had to be approved by way of a resolution passed by the Board of Directors. However, no such resolution was passed by the board and was placed on record, which could help the appellant's case. It was provided that no document was placed on record demonstrating that the board had approved payment of his remuneration to the appellant for his position as a director. Appellant's reliance on Article 19 of Articles of Association is also misplaced, as Article 49 does not provide for payment of remuneration to a whole-time director as a matter of course. The tribunal ruled that the appellant was not entitled to any further remuneration because he did not perform any directing tasks throughout this period. Furthermore, the matter cannot be brought up under the code IBC because it was a contractual matter in nature and stems from the employment contract.